So, as we know that the recent amendments and as Sir has rightly pointed out, 1940, the 1996 Act, and followed by 2015 Amendment, 2019, 2021, and now in 2024. So, how do you feel from your viewpoint, from your practice area, that this is going to introduce new issues or going to take away the challenges which we are facing so far in in arbitration practice, or is going to strengthen the arbitration or making India as an hub for arbitration?
Thank you, Iram. Honorable Mr. Justice K.V. Viswanathan, esteemed panelists, ladies and gentlemen, namaste and a very good afternoon to all of you. It is my proud privilege and honor to be a part of this august gathering today and to be speaking alongside such esteemed panelists. Now, in recent years, India has shown significant strides in positioning itself as a prominent destination for domestic and international arbitrations. The amendments in 2015, 2019, and 2021 were all intended to align our system with global and contemporary trends. These amendments were very well intended and also achieved to a large extent, if not entirely, the purposes with which they were brought in. But at the same time, they did throw up some issues which I consider minor aberrations. I will just give two examples. Section 11, as we all know, has seen an evolution of sorts. And over the years, both the legislature, by introducing various amendments, and the courts, by their judgments, have given due importance to tribunal autonomy. That said, the balance between tribunal autonomy under Section 16, on the one hand, and the interference by courts at the pre-referral stage, at Section 8 and 11 stage, the balance is fragile. And this fragile balance is evident from the numerous judgments on the scope and ambit of Section 11 and the unending saga of judicial interpretations. From Konkan Railway, where Section 11 was, exercise of power under Section 11 was held to be an administrative function, to SBP Patel Engineering, where it was then held to be a judicial function, to then the judgment in National Insurance Boghara Polyfab, which further enhanced the ambit of court interference, on the one hand, to the amendments in 2015 11.6 and the recent pronouncements on the scope of that 11.6. So I must say Section 11 has come a full circle. But despite all the conundrums, there is light, and Section 11 has been the life support to the field of arbitration in India. I'll give you one more example of Section 36. Now, prior to 23rd October 2015, mere filing of a Section 34 petition challenging an award resulted in an automatic stay on the operation of the award. Section 36 was amended in 2015, and with this amendment, mere filing does not render the award unenforceable unless the court grants an order of stay on the operation of the award subject to such conditions as it may deem fit. So when this provision was amended, there was the first issue as to whether it is prospective or retrospective. And this issue was resolved by the Honorable Supreme Court in BCCI Kochi, which held that being a procedural amendment, it will be retrospective. Now there is another issue which is cropping up, and I was speaking to my dear friend Amit this morning about this issue that all practitioners face in courts these days. Proviso to Section 36(3) stipulates that when a court is considering an application for stay of an award for payment of a money decree, the provisions of Civil Procedure Code will have to be kept in mind concerning stay on a money decree. Very well, no difficulty. In 2021, a second proviso was inserted, which now provides that if there is fraud or corruption in the making of the award, then it is the bounden duty of the courts, subject to a prima facie case being made out, to stay the operation of the award. Now this is leading to divergent views amongst various high courts. Few courts are now taking a view that the only ground for an unconditional stay on an award concerning money decree is to show a prima facie case of fraud and corruption, which, with respect, is not the correct approach. Fortunately, the Delhi High Court and the Bombay High Court are still saying that the discretion was always there, even without this addition of the proviso. And even in cases of money decree, if you are able to make out a compelling case, a stay can be granted, an unconditional stay can be granted. But these are, as I said, issues which I consider minor aberrations. When we strive to make any change, teething problems invariably emerge. As they say, गिरते हैं शहसवार मैदान जंग में, वो तिफल क्या गिरे जो घुटनों के बल चले.
So, as you have said about the interim measure, so I would like to now come to Sidharth. And before Sidharth, I'm asking this question to you. So let this thing to be clear to all the delegates who are over here, that Section 17 and Section 9 has its same effect, but one is before arbitration process and one is during arbitration process. So Section 9, when you read Section 9, it talks about interim measure during, before, and after arbitration. But now that during has been completely taken away from Section 9, and the entire power during the arbitration process is being given to the tribunal. So what if the tribunal is inefficacious or the tribunal is not available? So how you will deal with this issue?
Thank you, Iram. So, personally speaking, I'm not too much in favor of this proposed amendment. I understand building on the momentum from the amendments in 2015, 19 and 21, the legislature has now proposed this change to further reduce court intervention, facilitate timely completion, and encourage reliance on arbitral tribunals for getting interim reliefs. And as you said, draft bill proposes to modify the scope of Section 9 to now provide that during the currency of the arbitration, you cannot approach the court. Now, although, as I said, this is intended to encourage reliance on arbitral tribunals, as I see, there are shortcomings, and I'll just point out for everybody's convenience. This proposal, according to me, overlooks a situation where intervention of a court may be indispensable, particularly in situations where you have to go to the court for preservation of assets to prevent their dissipation, or where there is an immediate threat of dispossession, or there is an immediate threat of invocation of a bank guarantee. There could also be situations where the subject matter of the arbitration has to be protected, where an arbitral tribunal may not have jurisdiction over third parties. So you will need to have a court to interfere in those situations. Section 9(3) already envisages a situation that once an arbitral tribunal has been constituted, and should there be a requirement to go to the court will not interfere unless the Section 17 remedy is shown to be inefficacious. And as I see it, that's the ideal position. There is a safeguard already in place, and therefore, going forward also, I would urge and suggest that that's not a change that we should make in the proposed amendment. And as you also said, there could be a situation where an arbitrator is unwell, or he could be out of the country,
or not available for any reason.
Yes.
Okay, so as I understand, so you are very happy with Section 9 subclause 3, and you said that that is something which can cure the defects which we are having, or so this proposed amendment can be relooked. Okay, so now moving further, I'm going to now have a discussion with regard to the court judgment. That is, I understand few people, they came to me while coffee break, and they said this is the thing which we are facing, and they are from the railway department or so who are sitting over here. They said we are really upset about the kind of things now we are going to face with regard to our so many existed arbitration agreements, including me myself, because I represent government, and my many cases now, the appointment is now happening in a different manner. So starting with about the unilateral appointment or so, Sidharth, my first question to you is, The court judgment has reinforced the concept of equal treatment of parties, especially in the arbitrator's appointment stage. So, what impact do you think this judgment will have on the future of the arbitration in India?
Thank you, Iram. I would say this is a very progressive and welcome move. Independence and impartiality of arbitrators and equality of treatment, equal treatment at all stages is critical to maintain purity of justice. The most important stakeholder in the entire process is the litigant, the end user. And there should not be the slightest doubt in the minds of the end user that it has been shortchanged. In the core judgment, the majority verdict, there is an extensive discussion on the concept of bias.
Yes.
And when the Supreme Court discusses what bias is, they say the test is not to ask yourself, am I biased? The test is to look at the mind of the litigant. What is his perception? And bias is a facet of fraud.
Okay.
It's an important perception, so we have to look at it from the mind of the stakeholder. If we are to promote the culture of arbitration in India, and we expect end users to look at arbitral tribunals also as temples of justice, the way they look at courts, and not as some elite clubs, what Justice Viswanathan also mentioned, it is important that we ensure equal treatment. It's a must. No user should ever feel what is so beautifully explained in these lines. कहते हैं उसी का शहर वही मुद्दई वही मुंसिफ मुझे यकीन था मेरा कसूर निकलेगा. No user should ever be made to feel that. And therefore with this judgment, there is a need to now have balanced selection methods. There is task at the hands of legal professionals and those drafting contracts. They will need to ensure that the clauses do not undermine impartiality, do not undermine independence. There is equal treatment. And looking ahead, I am sure all of us will get over this sudden change and we will take it in the right stride. Of course, as you said, there is a negative aspect as well. It will dissuade PSUs and governments from opting for arbitration. But I think that's being too myopic. In the larger scheme of things, fairness, trust, as Justice Viswanathan said, that should be the end goal.
Thank you so much. Thank you so much. I'm glad to see your positivity. Thank you so much on this before I close this. So how we can make, in real sense, how we can make India as a hub and how we can retain the disputes in our jurisdiction so that the opportunity of should be given to our own people, it should not go.
Tejas sir and Dr. George have pretty much summarized the entire thing, but 2 or 3 cents. As I see it, our judiciary and legislature are doing all possible to ensure that we become a global arbitration hub, and therefore the intent is there. I'm coming to that. What we need to do is to have more and more workshops and seminars and congresses like these where we can exchange ideas, learn from each other's experiences, and learn about the global best practices and the contemporary global trends. We will need to do something about third-party funding, to have a more structured framework for a third-party funding. Third-party funding is a facet of access to justice. I'm not sure if the proposed bill takes that into account, but that's something we need urgently. If we really want, our jurisdiction to be at par with some of the other leading jurisdictions.
And I would like to, Honorable Judge, to conclude this.
I think it has been a fascinating discussion. At the outset, Iram, your questions have been very incisive and curated after a lot of thought. So, and the answers, of course, have been very interesting, diverse, and have offered, as I said, a virtual treat. Now, on the aspect of amendments, The responses were there. It was positive, evolutionary. One can't disagree with that. Two comments here that we have been firefighting. So by and large, the amendments have been reactionary. But of course, that is one way of going about it. But at some stage, we will also anticipate, and then perhaps some part of it is addressed in the 2024 amendments. But the second aspect is I find that while streamlining arbitration, the problem as it appears from the discussion and from the way it has evolved is not so much with arbitration as much as it has been with the courts also. Because at every stage you find that appointment, Section 8, earlier it used to be Section 34, which was, subject matter under the 40 Act, or Section 3 under the Foreign Awards Act. Then you have now the 11 issues which have, as Sidharth mentioned, from Rani construction till the recent one which sorted out the Section 6A issue post Vidya Drolia. So in 2015, you recollect the Commercial Courts Act was amended, and both the 2015 amendment and the Commercial Court amendments came on the same day, to 23rd October 2015. So it will have to be also addressed because it appears the substantial problem lies either in the pre-appointment stage, post-appointment stage, the interim stages. So if India is to be really a hub, that is an area which has to be addressed. And one way it is sought to be addressed is to decentralize the adjudication mechanism and take the definition of courts to the bottom. The other view is, should we have one arbitration court? But if it is one arbitration court, I don't know in what context Dr. Amit mentioned, if it is arbitration court at all levels, then that's a perfect model. Otherwise, it will clog the disputes. Today, the idea is we're trying to declog so that cases of lesser pecuniary jurisdiction go to the concerned courts. There also, we have so much cases that one court should be designated, but that is a balance we'll have to see depending on the pendency of other cases. So the point is that while amendments have been reactionary, maybe a need arises to anticipate and address the issue. The other is that reforms have to be also efficacious. No running away from the fact that it is also to be addressed at the level of courts, because even enforcement issues, foreign awards enforcement issues are getting also, delayed, etc. The emergency arbitrator, it's a no-brainer that I was part of the Amazon dispute arguing the opposite view, but we all have a cab rank rule, so we follow that. But it is a welcome measure. Now, the problem that arose in the discussion about deleting during from Section 9 and the possible vacuum that may arise, which you anticipate. Perhaps the idea they thought was that, no doubt emergency arbitrator, normally internationally it has a 90-day tenure till the arbitral tribunal sits. So maybe we could give that flexibility, and in the event the arbitral tribunal is not functional, that emergency window should be available. Otherwise, it will be a vacuum. What will happen is disputes will have to go to civil courts because every infringement of right will have to have a remedy. We just be remedium. So it will go back to court's point, which Sidharth mentioned in the discussion, that otherwise you will be now for arbitral tribunal not available, NIAN closing up and opening only post-award. Where do you go? So that is an issue unless you link it with the EA and give EA even at the stage of an unavailability. That's one way of looking at it.